Hello. Hello, Thad.
Hello,
Happy
Vicky.
New
Hep, it's New Year already? Well, how did that happen?
Year. Not really sure how that happened. We're already halfway through January. Isn't that wonderful?
You mean it's not November? Okay, we'll take that.
Great. I love it. I love it. Well, here we are on LinkedIn Live. And hello, everyone. Thank you for joining us, either here live right now, where you can add your comments and questions in the comments. Or if you're watching as a replay, we welcome you and we also welcome your comments. I'm Vicky and I'm joined by the fabulous Thad Hollis. He's my life partner and love of my life, a mediator, a divorce coach, and a conflict coach with 30 plus years in alternative dispute resolution. And today we're tackling a question that comes up all the time when people are facing separation. And that question is, should I go to court or is there another way? Do I call my lawyer first or is there another way? So a lot of people will assume that court is the only option and or that mediation, they've heard about this mediation thing and maybe it's the nice alternative that maybe won't work if things are really difficult. So we're going to unpack a bit of that today, break down what each path actually looks like, when mediation makes sense, when it doesn't, and how to make a choice that feels aligned with you. So, whether you're a lawyer advising your clients or you're personally trying to figure out your next step, we are looking forward to getting some clarity around this question. So, Thad, let's get right into it.
Yeah.
The
So,
question, I guess, is about starting with the basics. What is the real difference between mediation and court?
mediation is that facilitated negotiation. Court, we all know what that is. We've seen it on TV, the court TVs. And if we've had the opportunity to go to court for whatever reason, whether a traffic fine or any of those things that we can end up in court, there's someone sitting adjudicating with a gavel runs the show. So that's bit of sometimes it's like that, sometimes it's not, but it's basically you have a person making decisions and telling and imposing something. In mediation, my role is to facilitate a conversation. I am the facilitator. I ensure that the conversation flows. I ask questions. We do different things, but it is the parties are in control of the process. They are negotiating their own outcome with me helping them and keeping a safe space and keeping things flowing for them so that they're in charge. That's the easiest way to say it is that imagine that you wanted to negotiate something for yourself, whether it's a family matter and under family law or you know something in the workplace could be, or you want to buy a car. I don't know. It could be anything. And if you had a third party there to ensure that both sides had an equal power base, that both sides were able to talk and listen, that gives a balanced discussion to an outcome that allows both sides to fully explore what their options are. Well, if you go to court, there's an adjudication. There's a person sitting there who's going to go, this is how we're doing it. Think of I'm going to simplify it in terms of like King Solomon making a ruling. It's just going to be like, this is it. Based on the facts that's before me, this is my decision. Whereas in a mediation, you're making your decision. You're in control of the process. I'm here to guide you, help you understand what the requirements are, say in family law, what you may have as an outcome. And by all means, have a lawyer because knowing what your legal rights is important. Don't imagine that, American television or what you've heard from your mate down at the pub is a definition of what your legal rights are. In Australia, we have some very clear regulations and law under the Family Law Act. So we should be sticking with that and getting good, solid advice around that. But it doesn't mean that you've got to go straight to court. There is an opportunity to control your own process and be in charge of your process and do it in a good way with a better outcome.
Thank you for that clear distinction. And so, if I was to reflect that back, what I'm hearing the differences are is that mediation, you still are in control of the process. You get to be part of the dialogue Whereas in court, it's more of an adjudication. Someone else decides your outcome. Mediation, you help to decide your outcome by putting forward your thoughts, your insights, your needs. Court, you could still present those thoughts, insights, and needs, yet someone else is just going to make the decision. In your
Eh,
role as a mediator, you don't make any decisions. You help two parties come together to make their own combined agreement decision. Is that right?
Absolutely. It's not my role to tell people what's right, what's wrong. It's to help guide them, and it's always going to be child focused, right? It's not about us as adults, it's about the kids. It's always going to be the children. The court focuses on the well-being of the children too. As a matter of fact, the law requires that we all focus on the well-being of the children. That's what we're here about. It's not about, oh, how much can I get? Can I negotiate more out of this? It's like, is this going to serve the children? Are the children going to be safe? Are they going to be well? Do they know? Are they going to be able to have a roof over their head? Is there going to be some sort of maintenance? Is there going to be any requirements? How do you negotiate that and still keep everything intact? And in mediation, we look to make sure that you can co-parent to the best of the ability. If you can't get to an agreement and you end up going to court with a lawyer, you're going to have a lawyer there who's going to walk you through the process. And oh, major distinction, just that I do want to draw, is that in mediation, if you can control your process and have your own negotiation, imagine that you've decided to leave and now we're 6 months in and you've started the mediation process in a relatively short period of time. Within another few months, you could actually have a parenting plan that you've agreed to voluntarily. If you needed to convert it into a court order, you can go to a lawyer. You can have a property settlement, which we can talk about in terms of full disclosure, but you can do all of that within a relatively short period of time. If you go to court, it's a process that starts once you go to you engage. It's filed. It can take a year. It can take up to 3 years, depending on availability of the court, complexity of the issues, availability of your lawyer, availability of their lawyer, availability of the parties. When the court can give you the time, there's a lot more moving pieces that can delay it. And imagine kids not knowing when they can see their parents, or where they're going to be, or how they're going to be sharing time, and whether they can. There's a lot of more difficulty and stress and expense going through the court system than negotiating your own outcome.
Hmm. I can really see that would be a real benefit to if what you're looking to do is find a resolution within a short period of time, to have that conversation, a facilitated conversation with a mediator. Sounds like that would be an advantage. Um, my question is, once a couple mediates, they've decided to separate and divorce, they go to mediation, they see you, and they have their conversation and they come to an agreement. Do they still need to go to court after that to finalize things? How does that work?
If they can't reach an agreement on how to implement, say, they in mediation, they've negotiated and come up with a parenting plan. And I have a pro forma that we'll use for that to help them think of all the things like, school drop-offs, pickups, what to do over holidays, Christmas, Easter. What do you do with the school holidays? Who's got what? All those little details that we often don't think of until they're in front of us. We try and capture a lot of that in the parenting plan. Now, if there's a difficulty with the parenting plan and it's not being agreed to, it can be taken to a solicitor and then it can be filed into the court to be turned into a court order. So now it has the weight of the court behind it to say, this is what we've negotiated. The court will review that to ensure that it's in the well-being of the children, is maintained, and then issue an order. I'm making it relatively simple, but that's the simplified process. Always, there's one exception too. I wanted to talk about that. In the case of domestic violence or really high conflict, there may be the only option of going to court. I have mediated cases in high conflict in which I've done it by shuttle, which means that we've had the parties in separate rooms, and I've done it on Zoom in separate rooms where they actually don't communicate or see each other. That can work to get to an agreement, and then how they will communicate going forward in the well-being and best interest of the children. That is possible in a high conflict situation. If there's relatively amicable, and a lot of divorces can be, we've agreed the marriage is ended, we're really concerned about what's going to happen with the children, and we're not weaponizing the children in this process to get leverage over the other parent. It's perfectly possible just to sit down and have that talk. And imagine sitting with me and we have that facilitated dialogue that is just to get to a negotiated outcome. That's a win-win for everybody.
Yeah, that sounds
Yeah.
fantastic. And then once you have that outcome, is there any other step that, or are you done? You have your agreement. Like, so my question is, a couple decides to separate and divorce, they
Mhm.
mediate how they're going to do it. Then to have the divorce, does that need to go to court? Or what's the step to be divorced?
Well, the stuff to be divorced is you can choose to file it with the court, or if there's a simplified version is get legal advice is the best way to do that. I mean, you can, in some
You'd want
instances,
to engage a lawyer
yeah.
to
I
complete
always
that
I
process.
always recommend to clients that, for instance, I was commencing a mediation and we began the intake, and I did ask um, the person that initiated the mediation and that had initiated the separation had co- had a coach, a divorce coach to help, and had retained a solicitor to get legal advice as to what the rights were. The other party was absolutely, and when I spoke to them, I went, "Have you gotten any legal advice? Are you getting any emotional support? Are you talking to anyone that can assist you?" And they said, "Well, do I need to talk to a lawyer?" I said, "Make an appointment with a lawyer, and there's some questions you want to ask about what your legal rights are, how you get time with the children, what's going to be important, and just without saying I want to engage you, but you can get information as to what your rights are." I can't tell you what that is because I'm impartial as the mediator,
Mm.
but a lawyer can certainly guide you. And then once you have that information, you'll now know, and then we can certainly have a conversation. The optic
And
of
you
that
also,
one, yeah, sorry.
sorry, go
I was
ahead.
going to say the optic, there was some good news here. They actually had taken time based on our intake conversations and what was happening, is that they both reached out and had a telephone call and are now in the process of attempting reconciliation. So it's not
Beautiful.
always that as the mediator, I'm going to have gloom and doom and talk to the parties about how to negotiate their separation and have time with the children and a property settlement. There are opportunities to sort of hesitate, to pause and say, is this something that's really in our interests and in the interests of our kids? Is this something we really want to do? Do we still really love each other? So there's always opportunity. I don't have to present that. It's just talking through what divorce and separation really looks like.
So interesting. So when two parties speak, perhaps for the first time in a long while, or with new information at hand, and they
Mm.
truly understand the implication of what divorce means in the longer term, they may well find that, from what I'm hearing, that they'd rather just give it another go and see if it can work. But
Yeah,
there's no
it's
agendas here. We're not.
no.
I hear that there's no agenda here. It's always up to the parties. And you mentioned earlier that you do also engage lawyers, or you will encourage a client to have a lawyer at a mediation. Just talk us through how
No.
that works. And
What we
what
call
is the difference between having a lawyer without a mediator and having a mediator with a lawyer?
okay.
Are you clear on
Um,
that question?
yes. You can certainly retain a lawyer, and the Family Law Act does require that you attempt mediation. Now, you attempting mediation might mean you reached out, the other party didn't respond, and so the mediation failed. That can be retaining a lawyer, and lawyers will advise on your rights under law and will be looking as you as the client and what's in your interest and the interest of the children, and they'll be guiding you on that. In mediation, I'm perfectly comfortable with the legally assisted. That means having the lawyer in the room to assist the client, whether we're in shuttle or we're collectively sitting in the room together with, imagine the two clients and the couple separating, as well as having legal representation sitting there. Perfectly okay. I love working with that process because it also means that should something come up that requires clarification under law, the legal advice is already there. Also, if we're getting to the point where we're getting a parenting plan and we're finalizing that parenting plan, there's an opportunity to, I always tell the client, look, take the parenting plan with you, get legal advice, and come back and we can sign it. We may need to switch it. It depends on nuances. I, it always, every case I have is individual and is working towards the interests of the parties. And it's never a cookie cutter approach. And the hundreds of cases that I've done, thousands of cases that I've done, there's never, there's the similarity in process, but it's always individualized to the best outcome of the individuals and what they need in their process and what I can do to facilitate that. So if
Hmm.
it's legally assisted and that's in the best interest of the client, I'm happy to do that process.
I can only imagine that every case is very unique in the way they present and what their history is together as well, and what they want for the future. So, just we talked briefly about high conflict situations.
Hmm.
Now, I can imagine some people are thinking, yeah, my ex won't agree to a mediation. There's no way mediation can help us. He won't come to the table, or she won't come to the table. So, what is your view on that? And is that a truth?
I've had cases in which they've just refused to participate, that they think, and based on the advice that they've received, that they don't need to participate in mediation. And it has surprised them to find out that later when they're going to court, the court said, did you attempt mediation? And they went, well, we turned it down, and the court will send them back to attempt mediation again. I've had a case where that actually happened. But it's also always in the interest of the parties to try and have a conversation. So when I reach out and I have to make 3 attempts, and it's a phone call, an email, a text, and then a letter, say phone call or text, but it can be a letter as to my final attempt, is that I will always try and encourage them and persuade them in a non-threatening and in an open way to participate in a process in which it is voluntary and they can withdraw, but it is up to them to be in charge of their own process. So I've only had one case where someone in the last, say, the last 5 years, someone said, I'm not participating, I'm not interested. Everyone has at least attempted the intake and attempted to the best of their ability to negotiate in good faith. And I encourage that. And it will also encourage to make sure there's a balance in the power between the parties, that there's never going to be an imbalance where one party feels overly intimidated. So if it's a safety factor, I'll ensure that safety is there as well.
Hmm. Thank you for sharing that. And I'm also curious, you talk about the power balance. And
Mm.
what comes to mind with that also is the word compromise. Where I sit, I feel that compromise isn't a favorable thing because it means I'm giving something up in order to
Mm.
find agreement. What is your view from a mediator's standpoint on compromise?
Great question. There is compromise and there is selling yourself short. A compromise in a negotiation is always looking at what is the best alternative to to your negotiated outcome. Looking at, you know, if I give this, do I get that? So there's always going to be a little, I'll call it a little bit of a horse trading. But if you feel that you're constantly giving, 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 it's not a win-win scenario. It's now I'm losing, I'm not getting something. And that's not compromising, that's surrendering. And I'm not interested in the surrendering process. So I always check in with the clients when we're in this process. Is this what you really want? We'll have a private session. and I'll inquire as to what's happening for them, what's going on, what are they looking for, what is it that they really want to get as an outcome here. And if it's going to be, well, I want, yeah, I want everything. Well, that's not going to happen. Accept that. And isn't the other extreme isn't going to happen where you end up with nothing. Well, what's in between? What is it that you can live with, and what is it that you would like to negotiate? And it's always encouraging what are you willing to give, and what do you want to receive? Because a compromise, I know it sounds like I'm surrendering and giving up, but compromise can be a negotiation of a trade in exchange for something that you can live with. So it's maybe, I'll put in a parenting plan that you wanted to have 4 nights a week. And, for now, because of the situation with the kids where they're going to school, that it might be in the best interest that you get every fortnight, you get the weekend, and that you get you can have some other weekdays, and so there's some give or take. And we might consider that compromise, but I consider that effective negotiation, because it's what wins for everybody. And
And
that's
perhaps you
really
gain,
where the compromise can be.
and I wonder if perhaps each party gains more of an understanding around what is truly important to them in that process. So I feel that when we are curious and really go deep into understanding what is truly important to us, as you said, what can you live with? What can you live without? When we understand that, then I feel like that's less of a compromise and more of an understanding of self. Because I think sometimes we want something out of fear
Mhm.
or out of other emotions. We want it maybe to revenge or because we feel hurt. And when we truly sit with why we want it or why it's important to us, sometimes we don't want it as much. Have you
So
found that?
yeah, I think what's really key to help that is it's always a future focused. It's like in a private session, well, they cheated on me. Okay, well, they did that. That's why you're getting separated. We recognize that there's some hurt, there's some grief, there's some loss, and that's happened then. So, that part of the story that you have, this part of what your truth is, isn't going to help you tomorrow or next week or even next year. So what is it that we want to focus on getting into tomorrow? What do we want to look at for next week? So it's similar to some coaching, but it's as a mediator, I'll be inviting the parties to think future. What are we going to look like? Because imagine this, a couple's getting separated. They have children that are, I'll say, 7 and 5, right? Um, and they're thinking, okay, well, we got to deal with this. And I say, a parenting plan isn't a forever. It's a for now. But you also want to make sure that you keep lines of communication open, because in 10 years, they're going to be 17 and 15, and their needs are going to be very different than they are when they're 7 and 5. And then imagine when they're 27 and 25, their needs are going to be different again. And if you're still going to be in their lives, and they're going to still be in yours, and they may now be grandchildren. So let's not, and I said, let's focus back on what do we need to do today to make sure that communications are good tomorrow and next week. How is that going to help? How is that going to benefit the children? What's in their interests going forward? So it's always focusing the client on how to do this better. And revenge is never going to get an outcome that anybody wins. Revenge is going to feel, well, it's going to feel like grabbing a bucket of steam. It burns and your hands are wet and you have nothing left. Whereas future focused, thinking forward, there's rewards and dividends that are just going to be continue to pay because the kids are healthy, the kids are happy. Kids bounce, they adjust so quickly to new circumstances. And parents don't. Adults are a little harder to and a little less resilient. They're more pliable. Children, on the other hand, this is fun. We have a new bedroom, we have this, we have that. And working those accommodations and what the kids need always is a win.
That sounds like something about there's another conversation there about how to talk to kids during separation and with parenting plans and expectations and stuff. So I think we should definitely put that up there as a topic for one of these sessions
Oh,
together. I know
I
next
agree.
week we're talking about, or not next week, but in 2 weeks, we're talking about what healthy closure actually looks like after the relationship ends. So we're getting closer to that topic. And thank you for sharing the differences today between mediation and court and what
Court.
people can
Mm.
expect and what it actually costs to do mediation versus court. We weren't talking dollar figures, but we were talking what it costs emotionally, the
Fraction.
finances,
Yeah.
the time
Yeah.
that it takes. And there's just one more thing, if we can sneak this one in before we wrap up, is this kind of belief that, oh, if I'm separating, I need to find a tough lawyer because maybe that's what your
Mm.
friends or your mom has said, get the best lawyer because there's this fear that we're going to get taken for a ride by the other party.
Yeah.
What, I mean, does, I feel like if we have that view, then
Hmm.
mediation it feels less attractive because people feel like mediation's the more gentle route. But from what you've described, that's not the case. That's a myth because mediation helps you get to an agreement that may well suit you better than lawyering up and having a tough lawyer who's going to fight till the end for all the stuff that perhaps you don't really want in your heart if you were
Mm.
sitting with it and thinking about what's best for the long term.
Yeah. And having a really strong advocate, and that's fine if that's what you have as a lawyer, but keep in mind that there's an expense, there's time. Mediation is a fraction of the dollar cost, but also a fraction of the length of time. Imagine 3 years of lawyers exchanging letters. The kids you still haven't got a parenting plan together. You're waiting for the court to impose one. And so any opportunity to have a voluntary outcome is always better rather than an imposed one. And I've been doing this a long time, and it's always been my experience that a voluntary agreement is far better than one imposed because the parties own it. It is their agreement. Whereas if it's something the court has handed down, neither side's going to be very happy with it. They're both going to feel that they've gotten something less than they would have. And often there are things that are omitted or added into a court order that would make them feel that it would have been better off if they could have sat down and done it themselves.
So interesting. Yeah, and I guess there's no right time or it's never too late to go to mediation. Do you have clients who are already divorced, for instance, and then they come to you for mediation over certain aspects of an agreement?
I, I have done a mediation in which couples have been divorced, and it's been maybe about 7, 8 years now. And they wanted to do a new parenting plan because they couldn't
Mhm.
agree between themselves. And it was really actually because we spent more time in the intakes exploring what they were looking for than when we got them into the room to talk about the mediated outcome. It was 30 minutes because they'd already done their homework and knew what they really wanted and how
Fantastic.
this was going to help the kids as teenagers more than, so what their personal agenda was moved really quickly to the background, and what came to the fore was, oh, this is really going to help the kids more and make our lives easier too because the kids are going to have their needs met.
Fantastic. I love that. So really, mediation is available to people at any time. And
Yeah.
today we've been talking about separation and divorce, and of course, any kind of conflict that requires some resolution, mediation is an option for that
Yeah,
at any time. Yeah.
at
Well,
any time.
thank you, Thad. Thank you so much for your wisdom and experiences and insights. And thank you to those of you who are watching, either live or on replay, for spending this time with us today. This is something that we're doing on a semi regular basis every week or so, although it'll be 2 weeks before the next one. So the next one is about what healthy closure actually looks like after a relationship ends, and that will be, like I said, in 2 weeks' time. So choosing to go to mediation before court is one of the biggest decisions that you'll make during separation. And we hope that today has given you some clarity on what's right for your situation. And if you're not sure, you have some questions, you just want to talk it through about how it applies to your own personal circumstances, just drop Thad an email. He says he's available to chat, and the first consultation or the first conversation is complimentary. You can just reach out at admin@betteroutcomes.au. Admin@betteroutcomes.au is the email. And of course, drop your thoughts and questions into the comments and we'll reply, respond, and love to connect next time in 2 weeks' time.
Yeah, 2 weeks.
Fantastic.
Fabulous.
Have a wonderful couple of weeks. See you then.
Yeah. See you all then. Thanks for tuning in.